Ready, start. The petitioner's contention essentially raised in the above writ petition is that the petitioner having availed of an amount of less than rupees 1 lakh, the respondent bank cannot proceed for recovery under the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act in bracket SURFACE 2002 for reason of section 13 in bracket H of the Act. In fact, this court in OP in bracket DRT number 71 of 2014 answered the specific issue as hereunder. Para. The petitioners rely on section 31H, which excludes any security interest for securing repayment of any financial asset not exceeding 1 lakh rupees from the application of SURFACE Act. The learned counsel for the petitioners also points to the statement of objects and reasons which refer to loans not exceeding rupees 1 lakh. Para. The issue hence is no longer res integra. However, the learned counsel for the petitioner contends that one another ground has not been considered by this court in the aforesaid judgment. The learned counsel specifically points to clause J of section 31 of the Act, which refers to the principal amount and interest thereon. It is the contention of the learned counsel that when clause J refers to principal amount and interest thereon, what was intended by the legislature, even by subsection H, was that the principal amount shall not be in excess of rupees 1 lakh. If that were the intention, it cannot be so garnered from the specific words used in subclause H, which speaks only of financial assets. Para. As has been noticed above, the financial assets has been defined as debts, which terms as per the incorporated definition means any liability inclusive of interest. This court cannot and should not go beyond the specific meaning assigned to a word, and interpretative exercise to ferret out an assumed intention would be unnecessary. The principal amount availed through less than rupees 1 lakh at the time of recovery along with interest if the amount exceeds rupees 1 lakh. Para. The petitioner also asserts that there is an anomaly which is follows recovery of a loan in which the principal amount is less than rupees 1 lakh, which would be capable of being proceeded under the SURFACE Act if no default it exceeds that limit, whereas any debt in which total arrears would be much more cannot be recovered under the enactment if the total arrears due is less than 20% of the principal amount and interest as prescribed in clause J. Primarily, it is to be noticed that the acceptance of the petitioner's contention would not cure that anomaly, since even then a loan of rupees 1 lakh and above would be covered under the Act, while no recovery of a higher amount could be effected if that arrears is below the limit in subclause J. Para. Then again the value of the security interest created would be relatable to the principal amount availed, always in excess of the latter, to take in every contingency of default. The SURFACE Act is a departure from the normal rules of adjudication and recovery. Normally, a creditor on default has to approach a civil forum to quantify the exact amount due, fasten it on the debtor, and then proceed for recovery from the debtor. The creditor, being a financial institution as defined under the Act, can, without any more than a default, proceed against the secured asset and take possession of the same. The legislature thought if it fit that if the total dues are less than 20% of the principal amount, it was deemed that a security interest which is presumably worth many times more than the dues need not be proceeded against. The normal delay in adjudication in such a case would not be detrimental to the creditor since the possibility of the debt exceeding the value of the security interest is then removed. It has to be found that the legislature has deliberately employed distinct and different words in the subclauses and there is absolutely no anomaly and a conscious intent to the contrary is discernible. Para. The above reason the above reasoning pursues this court to answer the question and raise against the petitioner. The writ petition is found to be devoid of merit and the same stands dismissed. Parties to suffer their respective cause.